I ask myself internally what I hope politicians of all parties will be asking. Why is it, and is it a good thing, that sentences in England and Wales are so much longer than sentences in France and in Germany and in Italy and in Holland and Scandinavia? I don't lie awake at night. I just don't. And I struggle to see how anyone could hold down a really demanding job if they really did lie awake at night. What I fear is that politicians generally don't really understand the judiciary, and if I'm being honest about it, don't really have it in their bones a feel for the constitutional arrangements that we have.
This is The Judges, Power, Politics and the People, hosted by the University of Law. This week, I'm speaking with Lord Burnett of Malden. Ian Burnett recently stepped down as Lord Chief Justice of England and Wales after 6 years in that post. In 2019, he and 2 other judges ruled that the suspension of Parliament under Boris Johnson was a political matter with which judges should not interfere. The Supreme Court thought otherwise and ruled unanimously that Burnett and his colleagues were wrong. Then came the Court of Appeal ruling in 2023 that the government's plans to send illegal asylum seekers to Rwanda were unlawful. Burnett backed the government, but he was outvoted by his fellow judges 2-1. He was educated at St John's College, Portsmouth, and studied jurisprudence at Pembroke College, Oxford. His practice at the bar was mainly in public and administrative law, where he carved out a career acting in public inquiries. These included the 1987 King's Cross fire, the convictions of the Guildford 4 and Maguire 7, the 1997 Southall and 1999 Ladbroke Grove rail crashes, and the inquests into the 1997 deaths of Diana, Princess of Wales, and Jodie Fayed. I began by asking Lord Burnett how he felt now that he was no longer in the top job and was retired.
I came to a very clear decision that after 6 years in office, it was long enough. For all sorts of reasons, but including that the job is an extraordinarily demanding one and a very tiring one. And also, after 6 years in a really big job, the job needs a change as well, in my view. And so I had come to terms completely with the fact that my life was going to change. I was looking forward to getting up in the morning without a very early alarm, looking forward to avoiding having to spend the first half an hour or hour of the day at 6:30 going through emails and getting back into control of my life. So I hugely enjoyed being Lord Chief Justice. It was a great privilege. It's a remarkable job. But I'm happy to have left that part of my life behind.
What do you think you'll miss most about it?
I think the real truth is people. People. I think in any big job, your professional life becomes pretty well all-absorbing, and professional colleagues become more than professional colleagues, and many become close friends. So too officials with whom one works. And not seeing all the people who one enjoys seeing all the time is actually the most difficult thing.
Although you will carry on with some of them, and you're going to be active, aren't you, in the House of Lords, I think it's right to say.
Yes, I'm hoping to be active in the House of Lords, and I'm also going to be active from time to time sitting in the Supreme Court, but I shan't be in the Royal Courts of Justice all day, every day. I won't be in the Temple as much as I have been, and so I won't be running into the people who I've been rubbing shoulders with professionally for over 40 years now.
And you won't be sitting on cases, of course, or sentencing?
Certainly not here. I will be sitting on the odd case in the Supreme Court.
Oh, right, okay. Can you do that as an extra?
Yes.
You can be called in.
Yes, the Supreme Court has the facility to have a supplementary panel of justices, and there are a handful of two or three retired Supreme Court justices and a former Chief Justice from Northern Ireland who are on the panel, and so am I. And Lord Reid has kindly asked me to sit from time to time.
So looking back at the 6 years, let's start with that. What do you think has been the most challenging part of it?
I think undoubtedly in terms of energy and struggle dealing with COVID. That was completely unexpected, and none of us was trained in how to deal with a public emergency of that sort. It was an example of how a handful of really big decisions are what matter, and the need to avoid getting too lost in the weeds. I had to make a really big decision when COVID lockdown started.
Which was?
Which was whether to keep the courts going as much as possible or not. Around the world, courts were simply shutting their doors. And I think
was that an option, actually closing them?
Yes, it was. And there were many people, including particularly in the legal profession, who thought that I should close the courts. And I think what happened around the world was that few people were looking over the horizon. It's difficult now to look back at those days in February and then March 2020 when lockdown came along. But most people seem to think, well, this is like a bad flu epidemic, and so it's probably going to be over in 6 weeks or 8 weeks, and so shut everything down and then you can start up again. Well, I'm no great scientist, nor do I pretend to be an epidemiologist, but I did read quite a lot of the expert material that was coming out at the time, and it seemed to me that was unlikely to happen. And so I took the view, and I must say Robert Buckland was completely supportive in this, as were senior
He being the Justice.
He was the Lord Chancellor at the time,
actually.
Forgive me, yes. That we had to keep things going. Because stopping and then restarting is much more difficult in life generally, actually, than winding down and winding back up. And the only thing we had to stop for a very short time were jury trials, because we had to put in place safety arrangements to enable all the large number of people who have to be present in court for a jury trial to be there. But we only stopped for 7 weeks, and then we started off gradually. And within months, the system was beginning to get going again.
Although, of course, we're still trying to deal with the backlog.
Yes.
I mean, there is a backlog that arose from COVID, and it's still being tackled, isn't it?
Yes, that's right. The outstanding caseload, roughly at the moment, is a little over 50% more than it was when COVID struck. And COVID itself is largely responsible for that. Additionally, as you know, there was a dispute between the government and the criminal bar, which led to action in 2022. That had an impact on the outstanding caseload. And the other phenomenon, which I think is not sufficiently understood, is that the mix of cases and the nature of the cases that are in the outstanding caseload, it's more complicated. It's bigger cases, it's longer cases. Most Crown Court trials only last 2 or 3 days. And all you need is for the average length of a trial to go up by half a day, say, and it'll have a very profound knock-on effect. And that's what the system is having to cope with at the moment. But can I just make this observation, that I think it's wrong to fixate on the outstanding caseload. The truth is, nobody would mind if the outstanding caseload were twice what it is, but they were all dealt with quickly. And so what I would encourage people to do is look particularly at the figures of the proportion of cases in the Crown Court that remain outstanding after 6 months and after 12 months. They're much higher than they were 3 years ago, but the position still is that most cases are dealt with relatively quickly.
So that was a huge challenge, but you think, on balance, that it's been tackled reasonably well.
Yes, I mean, all I can do is really reflect on what people say to me from around the world. One of the silver linings, it's an awful thought, of COVID was that it brought the judiciaries around the world closer together, because we all learned how to use Zoom and Teams. And so rather than limiting our face-to-face contact to visits, people coming to London or me going somewhere else, we were soon having Zoom meetings and Teams meetings. And there was an enormous camaraderie, particularly in the Commonwealth nations, of sharing experiences and all collectively trying to help each other get our systems going. And one of the things that undoubtedly was said often was that in this jurisdiction, we kept things going rather better. I don't like using the word, you'll understand that, but rather better than many, many others.
Well, you did better than the churches, didn't you? Which all closed down,
well,
as I recall.
I don't think I would wish to lock horns with the Archbishop of Canterbury.
I'd like to take you back now, right back to where you grew up and your schooling. You grew up in Sussex, I think.
Our family was based in Sussex, and I had grandparents who were in Sussex, but we did, as a family, travel. My parents, my father worked in Africa on 3 different occasions, and so we spent time as children abroad. He
was a newspaper executive,
essentially. He started as in both Ghana and Nigeria, running newspapers there as a very young man, and then later, in his mid-30s, he ran the Thomson subsidiary in Malawi, which had papers, printing factories, bookshops, all sorts of things. It was a very interesting...
so you moved all around the place?
So we moved around. And by the time we were there, I was 12, I think, and so I was being schooled in England. But
and did your mother work as well, apart from in the home?
She did on and off. And just as well, because unfortunately my father was felled by a stroke when he was 44, and so my mother had to pick up the pieces.
That was a bit of a blow for
the
whole family, I'm sure.
I was an undergraduate at the time. It's difficult actually to think back to how it really did affect any of us, but undoubtedly it was one of the most profound influences in my life.
Of course. So you by that time you were at university, but you went to school. You went to a Roman Catholic boarding school, I think, didn't you?
I did, yes.
Where was that?
That was in Portsmouth, in Southsea, St John's College, Southsea. It was a direct grant school, which was they've long since ceased to exist, but they were independent, but supported through a lot of state scholarships.
So did you go on a scholarship?
I did, yes. I did.
And you stayed there and you went all the way up, and you then, why did you decide to then go to read law at university?
Well, it's an interesting thing to think back at how things were. This is 45 and more years ago. The thinking was that I should apply for Oxbridge and do so in my 4th term. In those days, a lot of people finished their A-levels and then did another term at school.
Yes.
And applied for Oxbridge at that stage. And so the question simply was, well, what are you going to read and what do you want to do? And like so many people, I remember this vividly, sitting around the kitchen table with my parents when I was 17. And it was the, well, what are you going to do debate?
You must have a job.
which I guess many people have. And the law interested me. I was thought to be a reasonably good debater, for example, and I could speak in public. So I thought quite long and hard about it. We had a friend who was a lawyer, And I spoke to him, and he thought it might be a reasonably good course for me. And so I decided then that I would read law, and I was interested in the bar.
So when you went to university, you had that in mind as a career by then?
Yes, because I decided to read law. I have always said that I rather wish I'd read history, which is what fascinates me, and I read a lot of history. But I read law because I had decided by then I wanted to become a barrister, and it's quicker if you read law.
Yes. Just to go back on what you said about the tragic early death of your father, you said that had a huge impact on you. Are you saying it would have shifted your view of where you went in life or what you did, or in what way do you think, apart from the obvious loss?
Well, I think it imbued a real sense about the fragility of life and how you can take nothing for granted. And also I think it instilled in me a sense of caution when looking at things like finances. You know, you've always got to be aware that however good things may be at the moment, they may not be in the future.
And was your family left hard up?
Well, no, I wouldn't say that, because in fact what happened was that he had a stroke and was then in a very bad way and institutionalized for 13 years before he died, and he'd made reasonable provision. So, but things changed completely. Of
course,
yes.
Of course. So you then went off into the bar, and did you have a particular area of law that you were interested in?
Well, I think I was actually rather naive about what I wanted to do. There were areas of law that I studied as an undergraduate which I knew I wouldn't want to spend my whole life dealing with, and I was interested in law as it affects ordinary people, and I was very interested in what was then a sort of fairly nascent subject of administrative law that had interested me, and so I joined a common law chambers where in the early years, in those days, one did a little bit of everything. So I do, personal injury, family, landlord and tenant, contract, and some minor crime, not real crime. It was driving offences. So these were the days when the big clients of chambers were insurance companies, and in those days, insurers would pay for junior counsel to go along and fight careless driving cases and plead guilty to drink driving and all these things. And so one was in court day in, day out, actually learning how to be an advocate, learning how to convince magistrates.
Compared with life as a judge, did you like it at the bar?
I had an absolute whale of a time at the bar. I really enjoyed what I did. I was very lucky to develop a fairly big practice quite early on, and then became involved in public inquiries.
You did? I mean, that's really, I would say, where you made your name, isn't it?
Well, again, this is, in life, a lot happens by chance and through luck. So I'm trying to think how many years call, 7 years call, so only five years in practice. When the King's Cross fire occurred. And I was instructed as junior counsel to the inquiry that then followed. That gave me a taste for public inquiries and doing sort of huge cases.
Yes. Well, you obviously enjoyed it, and you were obviously very good at it. But how stressful was it? I know from speaking with Lord Phillips that he found doing the BSc inquiry incredibly stressful.
Yes, I have a way of sort of internalizing difficulty and recognizing that I'm being asked and paid to do a job and get on and do it. So intense hard work, that inquiry and then all the others I did, but not stress in the sense of worrying that we wouldn't be on top of a topic in time for the hearings that we were going to be doing. No deadlines. Most of us need deadlines to work to. If you don't have a deadline, you just drift. In my experience.
And if you were to, we can't go into each one. I mean, you dealt with a series of very big, high-profile inquiries. But if you were to pick one that you either found the most challenging or in any way the most satisfying in terms of conclusions, which would it be?
Well, I think the Guildford 4 inquiry is the one that I would focus on, because that was a case which threw up a lot of thinking about what was not working properly in difficult, high-profile criminal cases. And of course, it led not only to that inquiry, but then there was the Royal Commission that followed. That was phenomenally hard work. And we also had the inquiry in parallel into the convictions of the Maguire family, which represented a serious miscarriage of justice. And it led to profound changes.
It did. I mean, you touched on miscarriages, so let's have a chat about that. Do you think the system basically now is working adequately? There's always criticism of the current system for dealing with miscarriages, isn't there?
Yes. Well, no system works perfectly, because any system of justice depends upon fallible human beings. Fallibility usually without any underlying malice, or lack of bona fides, but sometimes fallibility, which is the result of people cheating, to put it bluntly. Disclosure has been a curse for years, and we still have cases coming out of the woodwork where inadequate disclosure has resulted in wrongful convictions. I don't think any system can get rid of them. But what we do need is an efficient and effective way of dealing with miscarriages of justice. Now, of course, this is slightly a nerdy special subject. Back in the days of Guildford 4 and that inquiry in the early 90s, there was no Criminal Cases Review Commission. There was a department within the Home Office which was responsible for looking at miscarriages of justice and referring cases to the Court of Appeal. And the decisions were made by ministers very conscientiously, in my experience of the decisions that I was aware of. But obviously one of the great reforms that came out of those miscarriages of justice was the Criminal Cases Review Commission.
It was. I mean, it has come under fire itself subsequently, hasn't it? I mean, how well do you think it's working at the moment?
Well, yeah, all organisations come under fire sooner or later, and sometimes fairly and sometimes unfairly. But I think the Criminal Cases Review Commission over the last, is it now nearly 25 years, maybe it's more, has done a pretty good job. Like all these organisations, it's actually starved of resources. And in the end, when you're looking at cases that might have gone wrong, it requires time of suitably qualified and experienced people. And that's expensive.
Could I ask you about one of the inquiries that you did, or really an inquest? You appeared as counsel in the Diana and Dodi Al-Fayed inquest. How was that? It was a very, very high-profile event. How did you find it?
Well, it was, I think, probably the hardest 6 months of non-stop work I ever did in my life. In advance of it, the coroner, or assistant deputy coroner as he was, Sir Scott Baker, who was a Court of Appeal judge, and I decided that we would look at every single one of the competing and inconsistent conspiracy theories that surrounded that crash in Paris in 1997.
Goodness, that's quite a piece of work.
We also decided that because we had a jury, we had to finish the whole thing in 6 months. I do reflect that if it had been a public inquiry and not an inquest with a jury, we might have rambled around for 3 years, but we had to do it within 6 months. We had a wonderful team of counsel and solicitors and administrators working for the inquests, and we went through everything. And what it really taught me is that the forensic process of exploring evidence through cross-examination is so valuable, because it was a very good example of something which had been the subject of book after book, article after article, just repeating whatever people had been saying as if it were gospel. And it all read fine.
Yeah.
It all read fine, as long as you didn't read two different conflicting conspiracy theories within a week or two of each other. And it all looked plausible. But get some of these witnesses to come along and then just ask them a few questions. And it demonstrated just how flaky the whole thing was. And in some cases, I won't give examples now, but it was simply a question of one or two questions which completely destroyed the whole edifice that the person concerned was trying to erect. And it was a fascinating, fascinating experience.
Do you have any particular regrets yourself over any one case that perhaps you think, I wonder if I really got the right result there?
That's a question I wasn't expecting, and I don't think even if there were one or two cases lurking at the back of my mind, that I would take this opportunity to tell you about them.
Or to put it another way, did you ever lie awake at night worrying about quite what to do, or a sentence to impose, or anything of that nature?
I don't lie awake at night. I just don't. And I struggle to see actually how anyone could hold down a really demanding job if they really did lie awake at night.
Is it a quality to have the job that you held, would you say?
Well, I think it helps, but I actually often agonized over sentencing decisions when I was both a recorder and then a High Court judge. Many of the decisions as a recorder were much more difficult than the decisions as a High Court judge.
Why was that?
Because there you're often making a real decision about whether somebody should go into custody or stay out. And that is a huge difference in terms of its impact upon a defendant. When you're a High Court judge, more often than not, you're dealing with murder. And so there's a lot of difficult analysis and thinking that has to be done about the minimum term, but you have a life sentence. Manslaughter decisions I found very troubling because the degree of culpability in manslaughter can range from the almost not culpable to the very culpable, and those decisions are hard. And the others that I always found I had to think really carefully about and did worry about were sentencing for sexual offending, where again the culpability can range very, very widely.
Can you just explain that a little bit? When you say, was that a worry that you don't know whether the person is guilty, or
No.
Or is it to do with the length of the sentence?
The length of the sentence.
Because how culpable were they?
Well, you look at the classic is you look at rape, and the sentencing guideline has a particular starting point, but the range is enormous.
Yes,
and so particularly in sexual offending, I think that is a difficult task, and it's also a very sensitive task because you'll never please everybody in sentencing. Indeed. And in sexual offending, it's even more difficult.
So you decided you had your successful career at the bar, and you then, as you say, you became a recorder, and from that you started moving up the judicial hierarchy. Had you always imagined you would become a judge?
Never. No, it didn't occur to me. I mean, I started as a sort of bright-eyed 22-year-old barrister, rather astonished that anybody was instructing me to do anything. And then, after a few years, particularly when the inquiry work and the public law work was building, and then I became one of the junior Treasury Counsel at quite a young age, it seems, well, sooner or later I perhaps ought to get into silk. And then that happened, and I enjoyed that enormously, and I was lucky enough to do a number of the really big public law cases of the day. And I got to be 49 and was working much too hard.
To the extent that you thought your health was at risk, or your family were complaining?
Yeah, I was getting very, very clear advice from home that this cannot go on forever. So it was in those circumstances that I thought, well, if they'll have me as a High Court judge, be a good move. I'll give that a go.
You'd have regular hours. You would be able to.
Well, and also
confine your work.
You're more in control in a way, although obviously you do the cases you're told to. But the biggest difference about being a judge is that you don't have the pressure of clients. You go into court to hear a case, and you're not there worrying about who's going to win. And I don't know whether that's a general view that judges would have, that the release of the pressure of clients and the luxury actually of being able to listen and then decide, as opposed when you're an advocate, you're going in and you really want to win for your client because that's what they want to happen. So that's a huge change.
It is, and also presumably you're in a position of power as a judge. Is that something that you were aware of at the time? Responsibility as well.
Yes, responsibility rather than power. I think it really important that judges don't go onto the bench with private agendas of any sort. And I've also thought it important that judges should strive never to become the story themselves.
Or become the story by accident.
Or by accident.
Well, they can't help that, perhaps, sometimes.
I mean, I was given very, very sage advice from a judge who had been a good friend and who I'd worked with before he went on the bench, who said, when you give judgments, try not to have anything in them that is calculated to grab a headline.
That's no good for journalists.
No. But but that's certainly
that was an aim.
That's how I looked at it.
And have you any notion of how you might be perceived, or how you perceive yourself in the sentencing spectrum? Do you regard yourself as quite a tough judge, or as a soft judge, if those terms are applicable, or neither?
Well, I think we've spoken before, Frances, and I have said publicly on many occasions now that there is no serious debate about penal policy in this country at the moment. We've got to the stage where one party, one of the main political parties, constantly is seeking to ramp up the length of sentences, and the other main political party is saying yes and do it even more. I'm caricaturing it, but there is an element of that going on. When one looks at what's happened to sentencing over the last 20 years, and I gave quite a heavy-duty lecture on this at the end of 2020 at UCL, in all areas, the average sentence given for serious crimes has gone up very significantly, very significantly. Now, is that a good thing? Is that a good thing? Now, in the short term, obviously, if somebody is in prison, they're not going to be committing offences outside prison. So that to that extent, crime is contained to some degree. But looking at things more broadly, I think there's a serious question about whether lengthening sentences is actually good in the public interest, good for society. And it's not only questions of the money that gets thrown at it, but I ask myself internally what I hope politicians of all parties will be asking: why is it, and is it a good thing, that sentences in England and Wales are so much longer than sentences in France and in Germany and in Italy and in Holland and Scandinavia? And is it actually producing benefits to society that can be measured, that are tangible?
And your answer would be that it isn't.
Well, my answer would be that such academic research as there is out there would suggest that it isn't. Now, punishment is one of the primary purposes of sentencing. It's not the only purpose, and it's a balance for society through its political system to determine how much punishment, pure and simple, should be determining sentences. But my real worry is that we've just had a constant ramping up, actually for as long as I've been a judge. And I personally need persuading that it's doing a great deal of good. And I'm not persuaded at the moment.
Well, you must have mixed views about the current government plans, because on the one hand, first of all, we're going to have the sentencing debate you would like. Secondly, we're going to be getting rid of short sentences of up to a year and their replacement with community sentences, short jail sentences, I should add.
Yes.
But on the other hand, the most serious crimes are going to be given longer sentences if these measures go through Parliament, which of course they may not. What is your feeling about that package of measures that have just been announced?
Well, they're going to come in legislation before Parliament soon, and I'll have an opportunity to look at the legislation in draft, the bills, and make contributions in the House of Lords. So I don't think it appropriate for me, on the back of the King's speech, which was inevitably in very outline, to make any detailed comments.
But from what you've just said, you would approve of the measures to reduce short sentences.
Yes.
But you would have concerns, or would like to look at the proposals for longer ones.
Well, so far short sentences are concerned, the position is much more complicated than most people understand. And this gives me an opportunity to make a point which I think needs to be made frequently, is that association with outcomes does not necessarily mean causation. So we keep hearing in public discourse that short sentences don't work because reoffending rates are very high. And that association is entirely true. What is often overlooked is that those who get short sentences of imprisonment have, as often as not, had many non-custodial sentences which have, as it were, failed. So I have long thought that many short sentences really serve no real purpose other than to punish, and none of the other aims of sentencing are served at all. And so I would certainly like to see more effective community penalties and punishments. There are ways in which punishment can be achieved with community sentences now, which couldn't be done even 10 years ago. So something I've long thought is true is that, particularly for relatively young offenders, rather than putting them in prison, give them a tough community sentence with an overnight curfew. Now, it's a few years since we were 19, 20 or 21, but that's quite a punishment for a young man. And similarly, community orders that have intense supervision by probation, that have work requirements. Now, all of these will require a great deal of enhancement by the government of the availability of probation support and of all the bits and pieces that are necessary to make community sentences available.
Resources.
Resources.
They will need resources.
A very good idea, in my view, that particular proposal, to make sure that only those who really can't be punished in a different way go to prison for a relatively short period of time. But please don't anyone think that at a click of a finger that can be achieved, because the probation service isn't in a position to deliver at the moment, and it will need to be nurtured, enhanced, and please don't think that this will be a cheap option, but it will help reduce the prison population. More importantly, it's the churn of short sentences,
yes,
which is very labour-intensive for the prison service.
Yes. Now, how do you sell this to the public? Because it is one of the problems that the judges generally have views such as you've just set out, and the public are more punitive, I think, are they not?
Well,
that's why the government are proposing these tougher sentences.
I would simply answer that by saying, well, are they? It's true that when people don't know the circumstances of the offending or the offender, some are apt to think, well, whatever sentence was imposed wasn't long enough. But the Sentencing Council, when it works up its guidelines, does a lot of what in effect is market research to try to find out what people think. And the reality is that when people know the facts, when they know a little bit more about what's going on, then they understand.
You don't think there's a mismatch between what the public wants and feels and the kind of people who become judges or who reach the top of the judiciary?
I just don't feel I'm in a position to gauge what the public feels, because we got 68 million people in the United Kingdom, 60 million of them roughly in England and Wales. Yes. I can't remember how many are adults, but...
Well, I think polls have shown, haven't they, that people generally think that sentences have been soft or have not gone up, when in fact they have, as you said. They've gone up a lot.
But that rather is the problem, isn't it? Normally in life, you don't accord much weight to a view which is detached from reality. I appreciate politics is different, and I don't mean that discourteously. It's simply that that's the way life really is. But you've put your finger on it. If you were to take a poll of people not in the Strand here, but go into a big town in England and Wales and just take a poll and ask people, have sentences gone up in recent years? I suspect you're right that most people would say no. But given that that fundamental premise is wrong, should we be reacting and deciding policy on the basis of premises which are demonstrably false? Or should our political class be saying to the public, actually, this is the reality, and let's have a debate on the reality, not on fantasy?
When you were Lord Chief Justice, you had to deal a lot with ministers. How did you find those dealings?
Well, I think I had quite an advantage when I became Lord Chief Justice, that I had spent a great deal of my time at the bar from about 1990 onwards. So I was quite junior, advising the government. About half my work was advising the government in one way or another, and dealing with senior officials and ministers. So I had a reasonable amount of experience of it. It was something that I always enjoyed, because ministers, even if sometimes in public they get a really bad press, pretty well all of them are there trying to do their best for the nation as they see it. And so it was always interesting. I had cordial personal relationships with all of the ministers I had to work with: prime ministers, secretaries of state, law officers.
Did they listen to you?
Yeah, certainly, they listened.
Did they ever turn down your requests, or not seem to be sympathetic to your concerns?
One thing I will never do is breach any confidence, but it would be a very odd state of affairs if in 6 years of activity as Lord Chief Justice, with literally dozens of law officers and Lord Chancellors and a handful of prime ministers, that we saw eye to eye on absolutely everything. But the critical thing is that the judiciary needs to understand the position of the executive, and the executive needs to understand the position of the judiciary. We have to respect our different spheres of constitutional responsibility, and work to ensure that the whole thing functions properly. And the same with Parliament, because I have relationships with Parliament.
And looking at those three arms of the Constitution, the judiciary, which you were heading, of course, since the constitutional reforms of some years ago, Parliament and the executive, do you think the judiciary had a proper standing, and do you think its power position is within those three? Is it equal?
It was Alexander Hamilton, he of the musical fame,
yes.
when he was vice president of the USA in the early days. He was quite a constitutional thinker, and he described the judiciary as one of the three arms of the state, but the weakest arm. And it's the weakest arm because in the end it doesn't make the laws, and in the end it needs the executive to fund it, or Parliament, and it needs outside agencies to enforce its will. So in terms of who's the most powerful, it's not the judiciary. That said, I don't think any government would deliberately court a fight with the judiciary, because, to use that marvellous phrase which led a cabinet minister 30 years ago to storm off an interview, Sir Robin Day described him as here today, gone tomorrow, which was not very polite, even if accurate. I mean, the judiciary carries on. So there's never been, in my time, a fight between government and judiciary.
No.
We've had different points of view on certain things which we resolve privately. I think it's really important that these differences of opinion should be resolved privately and responsibly, and not erupt onto the front pages of newspapers.
Have you actually seen Hamilton, the musical?
I regret to say I haven't. I've read much of what he wrote, but I haven't seen the musical.
Okay. Because actually music is one of your loves, isn't it?
It is, yes.
Do you sing or play an instrument?
Not now. I sang a lot as a boy treble, and then
in a church choir,
in a cathedral choir, and then
which cathedral was
Portsmouth Cathedral, and I then also sang when I was an undergraduate. I played the piano indifferently, and so I gave that up, save occasionally late at night when I was moved to try something and play it very badly. But I listened to music all the time. I couldn't function without.
Who is one of your favourite composers?
Oh, well, it depends on my mood. I don't know if I'm the only person who thinks this, but when I'm feeling, I love opera, and at the moment I'm listening to a lot of Rossini, underrated in my view, and I love all the bel canto operas, so Bellini and Donizetti, and then moving through to Verdi. If I'm in a gloomy mood, I listen to Wagner.
Sorry, this was a digression.
No,
anyway,
you've got me going. I could go on for hours.
Come back to the relations with judges and ministers. I'm just wondering whether you think, and maybe not in your time, but in the last, say, 30 years, the relationship has changed. We've had a massive turnover of Lord Chancellors, as you've mentioned. Mm-hmm. Your role as Lord Chief Justice is different. It's more powerful in that you have to represent the judiciary. And has there been, I wonder, also a change in attitude from some ministers to the standing of the judiciary and maybe the rule of law?
Well, what I fear is that increasingly politicians generally and some ministers don't really understand the judiciary, and if I'm being honest about it, don't really have it in their bones a feel for the constitutional arrangements that we have. And that's not just the judiciary, it's Parliament as well. And I do think that the change in the nature of the Lord Chancellor has had an effect in reducing the power of a voice at the centre, speaking for the judiciary and for the rule of law. You'll know that I've now spoken on a number of occasions about my personal view that the Constitutional Reform Act arrangements need looking at, and in particular the role of the Lord Chancellor. I think
you would like a separate Lord Chancellor again, separate from the Prisons Department, for example.
And what I envisage is the need for a Lord Chancellor whose primary function is to look after the justice system, regulating the legal profession, be responsible in government for the support of the judiciary, the rule of law, and also probably constitutional matters, which would fit very neatly with that. My own view is that having the Lord Chancellor, with all his really important statutory responsibilities and constitutional responsibilities for the judiciary and the administration of justice, lumped together with prisons and probation, has meant that the focus not only of the ministers, but also inevitably of the department, is principally on those things which are politically difficult. Now,
to the detriment of the judiciary, legal aid, or courts?
To the neglect of all of the other aspects. So I think I months and months and months ago said publicly that with prisons, a crisis in the prisons would inevitably divert the attention of ministers and officials. Now, we are having a crisis in the prisons, as we know, because they're full, and the government is now having to take measures to reduce the pressure. But that is an enormous problem, which I don't personally think should be absorbing the time and energy of the cabinet minister responsible for the administration of justice and the rule of law and the regulation of the legal profession, legal aid, and all these other things. And the other thing that is so striking about what's happened in recent years is that we've moved away from Lord Chancellors being appointed for a long period. We've moved away from Lord Chancellors being appointed who have been very senior ministers and doing the Lord Chancellor role at the end of their careers. In other words, having somebody responsible for the administration of justice, speaking for the rule of law, speaking for the judiciary, who isn't looking for the next job. And so being absolutely blunt about it, I don't think it's good for the administration of justice and all of the things that surround it to have what is perceived to be a middle-ranking cabinet minister who, frankly, would like to be a more senior-ranking cabinet minister there for a relatively short period. So look back at what we had. Obviously, pre-Constitutional Reform Act, the likelihood was that a Lord Chancellor would be in post for a whole Parliament. The Lord Chancellor would be able to insist that the Prime Minister give him time to introduce legislation for what I've always called constitutional plumbing. And it was a point, I think, that Lord Mackay, James Mackay, made to you when you interviewed him last year.
Yes, you'd like to turn the clock back in that regard, anyway.
Yes, not
all of those reforms.
No. Simply to have again, if we wind the clock forward, once the Constitutional Reform Act came in, and Lord Faulkner was the first Department of Constitutional Affairs. It sounds faintly Orwellian, but actually it was a good mix of things. Jack Straw became Lord Chancellor. He had been Home Secretary. He had been Foreign Secretary. He had no political ambition. And it was in his time, I think, that the prisons came over. And I know he and I have talked about this. He doesn't agree with me about shearing them off. Well, then there was a change of government in 2010, and Ken Clarke became Lord Chancellor. Now, he had been Chancellor of the Exchequer, he had been Home Secretary. There was almost no cabinet position he hadn't occupied. And again, he was somebody without political ambition. And since then, we've had a series of mostly very short-term Lord Chancellors. That, in part, has been due to the turmoil in politics generally since 2016 or thereabouts. But I don't think it's been good for the administration of justice.
Do you also see a change in the attitude in recent administrations to respect for rulings of the court, to the rule of law generally, and perhaps even, what about Boris Johnson? He's been accused of a flagrant disrespect for the rule of law.
Well, I'm not going to talk about individuals, particularly individuals with whom I had a professional relationship as Lord Chief Justice. Looking at it sort of more widely, there have been things said by ministers which, as I think I've put it before, suggest a less than confident grasp of what the rule of law means and what the independence of the judiciary means. And I think that is unfortunate, and I hope that we see less and less of it. We are seeing less of it. I would say that our current Lord Chancellor and our current Attorney General, both of whom I know very well, have the rule of law through their backbones.
So this is Alex Chalk and Victoria
Prentice, forgive me. The rule of law through their backbones, as if it were a stick of rock with Blackpool up the middle. And
that's what you would like to see?
And that's what I would like to see unequivocally from all ministers, actually. I mean, it's often overlooked that the one thing the Constitutional Reform Act did was to state that the rule of law is a constitutional provision, that the Lord Chancellor has particular responsibilities, but that so far as the independence of the judiciary is concerned, all ministers and all public officials must respect the independence of the judiciary, including the judiciary of international courts to whose jurisdiction the UK submits itself. And that means that you can disagree with a decision of a court. Of course, you can say, I'm sorry about that decision, I think it was wrong. But no minister, compatibly with the duties imposed by the Constitutional Reform Act, can attack the integrity of a court or the motivation of its judges.
What do you feel about proposals which flare from time to time about disregarding the European Court of Human Rights or withdrawing from the European Convention on Human Rights?
Well, the position in UK statute is that the decisions of the European Court are decisions to which our courts must have regard. The European Court itself doesn't have a system of precedent as we understand it. And as you know, the decisions of the courts here is that ordinarily our court should follow a settled line of jurisprudence from the Strasbourg Court. And that's what Parliament has said. And so that's what we do.
Do you think that constrains courts or constrains politicians, perhaps? They clearly do in some respects.
Well, it was, I think, Lord Irvine of Lairg, when he was Lord Chancellor, who, in the context of some decisions of the courts, which certain of the ministers in the Blair government didn't like, he said, you don't cheer when you win and you don't boo when you lose. And so
I remember.
You remember that. And I mean, the point he was making actually was a very straightforward one, that in our system, the courts decide cases, and if you don't like them, you can appeal them. And if you take a case all the way and you lose it, then in our system, with a sovereign parliament, the government can propose legislation. And if Parliament agrees, it can change the law.
Do you personally have a view about whether it would matter if we pulled out from the European Convention?
Well, I mean, I've been around long enough to have been arguing human rights cases in court before the Human Rights Act in 2000. And they were undoubtedly different in that the convention wasn't directly applicable. But we have seen cases, haven't we, where, for example, in the freedom of speech zone, where the common law has been pretty robust in giving protections. I think the same would be true in broadly privacy areas now. So
why don't we stick with the common law? I mean, would it matter if we did not have the oversight of the European Court of Human Rights? Would that matter?
Well, we've been party to the convention since its beginning. Leaving the convention would have very wide-ranging consequences. And it's not something personally that I have been persuaded is remotely necessary as a result of the particular difficulties that seem to animate some of our politicians.
And finally on this, would you say that incorporating the Human Rights Act into our law, enshrining it into our law, has that expanded the power of the judiciary? Well,
it required the judiciary to do something which it hitherto had not been doing. And that is consider questions of proportionality. Now, this isn't a time to go into the differences between our domestic administrative law and public law and the convention, but there is a significant difference between an analysis based on proportionality and the analysis in public law, which was based on irrationality and its adjuncts. And so it inevitably pulled judges into areas which are controversial. That was inevitable. It couldn't be avoided, and so that occasionally has caused politicians to get upset. I mean, they got upset more than occasionally before we had the Human Rights Act. But it also requires judges to be circumspect and astute to recognise the boundaries between the proper sphere of activity of the executive and the legislature and the proper sphere of activity of judges.
Talking about the boundaries between the executive and the judiciary, you famously led the ruling that Boris Johnson's suspension of Parliament was lawful. And then you were famously, even more famously, overturned. And it was a unanimous ruling. I'd like to ask you, first of all, how you felt about that. Were you upset about it?
No, well, again, in our system, and it's one of the ironies that the Lord Chief Justice sits from time to time in the Supreme Court and also is inevitably, given the nature of the cases I do in the Court of Appeal, or did in the Court of Appeal, because they're high profile and important cases, many of them go to the Supreme Court. And it would be extraordinary if any judge got too worked up about being overturned. All I think I would say about that decision is that it's well recognised that the Supreme Court moved the law on quite a way in its decision, and the other thing that
you mean it made law in its decision?
Yes, it made law in its decision. And,
whereas perhaps at your level, not you personally, I'm talking about, but at the lower
sitting
level,
in the Court of Appeal,
it would have been applying the law as you understood it.
I think so.
They went on to create a law.
And the other aspect of the case, which was perhaps rather different in the Supreme Court, was that the Supreme Court decided that the prorogation of Parliament was not a proceeding in Parliament for the purposes of the relevant legislation. Now, that wasn't argued in front of us because I assume it was thought to be unarguable. It wasn't actually part of the case that was argued before the Supreme Court either. So that was part of the decision that I at least was surprised about, because it wasn't even argued before the Supreme Court.
Is it right or appropriate for judges to extend themselves into areas like that?
Well, the Supreme Court, any court I've sat in, we decide the cases that come before us, and if we think it necessary to develop the law, we develop the law.
Is it appropriate?
It's sometimes unavoidable if that's the way the case is being argued.
Because that was a highly political decision. Were you surprised it was unanimous? I think many people were.
Well, the decision, for reasons that I understand, had to come very quickly, given the circumstances. And so I think it was within 3 days, wasn't it? You may remember it was over a weekend.
Yes.
That the decision was produced. So it was perhaps not realistic to suppose that in that time there would be
dissent,
multiple decisions or dissent.
Because they would have felt it necessary or at least desirable for them all to be of one voice.
I just don't know what.
You haven't discussed it with any of them since?
No.
I bet you have.
That's not what we do. It's not what we do. It really isn't, actually. It really isn't. And I have once or twice, as an appellate judge, had the judges who I've disagreed with take the trouble to explain to me why they think I was wrong. But I've never done it myself.
Did you think it was?
Nor would I, even if I did think it was wrong. But it's a question of constitutional responsibility. So here we dealt with that case in the divisional court, as you know. So we were sitting technically at first instance in the High Court. We had the three most senior judges in the jurisdiction. We formed our view. And our constitutional arrangements are such that in that case, My decision was subject to review by another court, and there it is.
It is, but I think people looking at it from the outside and thinking now of public perception will find it astonishing that you, the most senior judge in the land, 2 other very senior judges, and then you get 11 who just say, no, that was completely wrong.
Well, I don't think they put it quite as crudely as that, but I think those decisions, it's what now, 5 years ago, isn't it? Doesn't seem like it. Those decisions are for the academics, and they can argue over the bones of those decisions to their heart's content for years to come.
Well, what do you say to people who say it was a political decision? And some people will say, well, that judges who come from a particular kind of political spectrum of society. No. What do you say to that?
No. This is just not how it works. It's just not how it works. There were interesting and powerful legal arguments being advanced in that case, and don't forget that the claimant, one of the claimants, was Sir John Major, a former Prime Minister. So this wasn't politics.
It wasn't party political.
Sense,
no.
Even underpinning the claim itself, and the Supreme Court considered the arguments and dealt with the case according to the law and gave its decision. I mean, that's how our system works. And interestingly, the government hasn't legislated to reverse that.
No, that's true. Judges, do they leave their politics at the door of the court?
I'm confident that they do. Yes.
Do you know the politics of your colleagues?
Almost none. I'm not even sure I know my own.
Okay, well, finally, I'd just like to ask you, looking again at the power balance between the judiciary, the executive and ministers, is it about right? Has it changed? What are the threats, would you say, to that power balance, or indeed to the rule of law?
Well, I think things are in a fairly stable place at the moment. Our job as judges is to apply the law. Obviously, we have a lot of potent common law, but the controversial parts of the law that we apply tend to be interpreting statutes and the sort of lorry loads of statutory instruments we get now. And that's what we do. If the decisions are not welcome, they can be appealed. And if the appeal decisions are not welcome, then laws can be adjusted. But I think the balance in terms of public law is very well settled now. One or two decisions, particularly in the Supreme Court, have reasserted some orthodox views of public law, including one of mine. And I think that's put everything in a fairly calm position.
Threats, would you say media, or would you say funding, lack of?
Funding is always a really difficult issue, because one recognises that all governments have much more to spend their money on than they have money to spend. Wouldn't matter if they doubled the money the government had, it still would have pressures politically to spend more and more and more. But it's undoubtedly the case that over the course of my whole time actually as a judge, and even before that, spending on justice has suffered. And it's not, to use the term that I hear some politicians use, it doesn't have retail value. In other words, there's no votes in putting another 100 million into maintaining the courts, or building some new courts, or actually until now enhancing the quality of the prison estate and all these sorts of things. But in the end, a system that is starved of funds finds itself struggling to deliver to the public what we want to deliver. And there have been some improvements in the immediate recent past. Alex Chalk and I agreed an enhanced budget for court maintenance earlier this year. And we also got agreement from the government that the maintenance budget would not be done on a year-to-year basis, but would be we get 2 years at a time. So we know what's coming next financial year, which I think was a great development.
And it's not your area, but of course funding also for criminal legal aid and for barristers.
That was starved. It was cut right to the bone, essentially through not providing any increases for many years, even though obviously there was inflation. But again, we've had a recognition, I think, in recent times, certainly for the last year or so, that you have to fund these things properly. Otherwise, the system will just degrade.
You've left it in better shape, but what would your verdict be on the state of our system now?
Are you thinking the criminal
justice system, but particularly the criminal justice system?
Well, so far as the criminal courts are concerned, I don't think that the work that's been done in recent months and over the last year or so in trying to sort out the remuneration for criminal lawyers, not just the bar, most importantly solicitors as well. I don't think that debate is over, because the whole system of criminal lawyers has degraded over the last 10 years as a result of two things. The first is that the volume of work going through the criminal courts fell away for reasons that are too complex to go into, but it fell away. So the number of solicitors and barristers also began to fall away. Then the money got squeezed, and so more fell away for that reason. And what I think we're seeing at the moment in trying to recover from what's happened is that you can't rustle up lots of new criminal solicitors and barristers overnight. You can't flick a switch and undo the damage that's been done over really 10 or more years. And so I think that is something that is going to require the continued attention of government for quite a long time to ensure that the criminal legal aid fraternity, community, solicitors and barristers, is able to do the work that needs to be done and is self-renewing.
Well, without it, people won't be convicted, and victims won't get justice, and there'll be miscarriages.
Well, without it, we will be in a position, which on and off we have been now for the last 18 months or so, of having courtrooms available, judges available to do the cases if necessary, but one or other side, prosecution or defence, not being able to produce a lawyer to deal with the case. And that's terrible.
Your job is now filled by a woman for the first time in legal history. Do you think, what difference do you think that will make, maybe to public perception of the judiciary?
Yes, I think it does make a significant difference to perception. We've had a woman president of the Supreme Court. We've now got a woman Lady Chief Justice. We have a woman Lady Chief Justice in Northern Ireland. We have a woman Lord Justice Clark, the second most senior judge in Scotland. And we have just had the appointment of another woman to the Supreme Court. So these are significant developments which demonstrate that in terms of gender balance, what has happened already in the more junior ranks of the judiciary, forgive my using that expression, but everybody knows what I mean, where gender balance is pretty good, is finding its way up into the most senior ranks. And I think that that's an extremely good thing, and it's a very powerful statement of how the judiciary is changing, and albeit we lag behind, more reflective of society as a whole.
And of course, you're very keen on television cameras coming into court, and that's something you've pushed, and that will help, won't it, when people can actually see judges giving their sentencing remarks. I think you favour more of it, don't you?
I do. It took years to get that. It perhaps reflects the need to manage these things very carefully to get people to be supportive of it, because the legal profession it doesn't embrace change very enthusiastically, and it's not just judges. But I think that has been a really positive development, and what it's done, quite beyond explaining to the public how the sentences have been arrived at in these controversial cases, it's provided easy access explanation to journalists. So I think we're getting better reporting as a result, and the sort of uncovenanted benefit, certainly I didn't appreciate it as perhaps I should have done to the extent that it has happened, is that it's shown to the public that judges aren't all 80-year-old men, as you see in dramas. I mean, true, High Court judges are not very young because they've had very successful careers at the bar or as solicitors, and so they're usually in their 50s. But I think a lot of people have been rather surprised to see the number of women, the number of judges from ethnic minorities, and just generally that the High Court bench, who largely have been delivering the sentencing remarks that have been broadcast, do not look like the public perception. And so that's been really, really positive.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.